Our initial panel this morning got us off to a fantastic start, and we have much more to come this afternoon and after lunch. But right now, the highlight of our symposium, and that is today's Earl F. Nelson Lecture. You have the brochure. Earl F. Nelson, back in the 1920s, was responsible for establishing the Law School Foundation, realizing even then, about 80 years ago, the need for private support for an outstanding public law school. And his support and that of the Law School Foundation have helped us in innumerable ways since that time. In the 1950s, the Law School Foundation established this lectureship in Earl F. Nelson's honor, and you see in the brochure some of the luminaries who have spoken over the years. They include, I think, about a half a dozen U.S. Supreme Court justices. Last year, Justice Sandra Day O'Connor, several solicitors general, outstanding judges, lawyers, presidents, and one Nobel Peace recipient who have lectured as the Earl F. Nelson Lecturer. Today, in 2010, we are pleased and honored to have with us Stephen Bright as this year's Earl F. Nelson Lecturer. Stephen Bright is President and Senior Counsel of the Southern Center for Human Rights. He's been at the Center for almost 3 decades and has directed the Center for 23 years. He also practiced immediately out of law school as a legal services attorney with Applerad in Kentucky and worked as a public defender in the Public Defender Service of Washington, D.C. He has argued, and even more importantly, won 2 major cases in the United States Supreme Court dealing with discrimination within the jury composition. He's testified numerous times before the United States Congress and the United States Senate. In addition to his leadership of the Southern Center for Human Rights, Stephen Bright teaches at Georgetown University Law Center and has taught since 1993 at the Yale Law School. He's also taught at other leading universities and law schools across the country. His teaching, writing, and advocacy focus on legal representation of indigent defendants, capital punishment, and prison conditions and practices. The program lists just a small number of the awards and achievements that he has received over the years. The ABA's Thurgood Marshall Award, the ACLU's Roger Baldwin Medal of Liberty, NLADA's Kutak Dodds Prize, and NACDL's Lifetime Achievement Award. Stephen Bright has received honorary degrees from 6 universities, both in the United States and in the United Kingdom. He has given named lectures at many of the finest universities and law schools across the nation. We are truly honored to have with us today as the 2010 Earl F. Nelson Lecturer, Stephen Bright. Would you join me in welcoming him to the law school, to our symposium, and to Earl F. Nelson Lecturer.
Thank you very much, Dean. I can't tell you what a great honor it is for me to be back at this great law school. I think I was here about 18 years ago to speak here, and I enjoyed it tremendously. Your dean at that time was Tim Hines, who's no longer with us, but was a great person and a great dean. And I'm delighted to be back, and I'm delighted to see you addressing this subject. When I saw the schedule for today, and I saw that I was scheduled for this time, 10:15, I looked to see what was scheduled for 11, or 11:15, or 11:30. Finally, I called up 2 people that I thought would be an expert on this, Judge Jay Bybee and Professor John Woo. And I asked them if being talked to death was torture. And they both assured me that it would not be. Because, you know, they have a fairly narrow definition of torture. Just leave whenever you feel like it, okay? There's a lot to be said on this subject, but I also want to say it's great to be here with people that have contributed so much to this. So many of my good friends, in fact, 2 people who started with the Public Defender Service with me, Bob Mosteller and Richard Rosen, as well as other people who came, Barbara Bergman, later on, and the person we're indebted to for that, and the person that has been just a giant in this field for over 40 years, Norman Lefstein. We were able, in that last panel, we were talking about what public defenders do when the caseloads are too great. We were in a public defender office that when you knew that you were approaching your caseloads getting too great, you just simply were able to say, I'm not going to pick up any more cases. And it was because in 1969, Norman Lefstein and Barbara Babcock, in starting the Public Defender Service of the District of Columbia, what's been an exemplary program of demonstrating what a public defender can be like, were able to establish that the caseloads would be reasonable, the lawyers would be well trained, and that people would not have these crushing caseloads. And throughout his entire career, there has been no greater advocate. Nobody has written more, said more, done more than Norman Lefstein. And I just want to acknowledge great. And I also want to express my admiration for my good friends here at the Missouri Public Defenders. I've come back to Missouri several times over the 30 years that I've been in this work, and I have many friends in the public defender system here. I know how hard they work. I know how hard they have struggled with the staggering caseloads that they have and the insufficient resources, and I know that they have struggled to make the right to counsel a reality here in Missouri, and I know it's been hard. And you know, in the 1970s, we had about 200,000 people in prisons and jails in the United States, and that number had held relative to the population about steady throughout our history. And then we had this incredible explosion in the number of people to where today we now have 2.3 million people, men, women, and children, in our prisons and jails, and we now have the highest incarceration rate of any country in the world. All of this happening in this time period. And the federal government during this time has awarded millions of dollars to state law enforcement, state prosecution, to enhance prosecution, enhance law enforcement. There's another drug agency created, and that means more people are going to be arrested. If there's another program for this, that, or the other, it means more people obviously are being brought in and processed through the criminal justice system. There are more resources to do the prosecution, but at the same time, state legislators throughout the country, which were never funding indigent defense adequately to begin with, have not even begun to keep up with the fact that this huge, crushing burden of cases has been dumped on the state courts in this time period. And the courts have usually failed in their responsibility, as I will talk about, to enforce the Sixth Amendment right to counsel. And when they have done so, it's been very grudgingly, very stingy in doing so. And the people who have made the right to counsel a reality in this country and in this state are the public defenders and the other lawyers who have taken on cases and represented the poor despite the crushing caseloads, despite the lack of resources. They've worked long hours under the immense pressures of having people's lives in their hands, people's liberty and sometimes lives in their hands. Too much work and too little support. And I want to start by commending the public defenders for the tremendous work that they do in representing people, and the other lawyers who represent people. It's a thankless job. And I know there are many times when people say, can this cut be passed? And yet stay with it year after year and sharing their expertise with the younger lawyers that come into the system and with the clients, of course, that they serve in doing so. Well, the question that I've put up on the board here is one that sums up our situation to some extent. You've got a pretty good case. How much justice can you afford? Of course, some lawyers whoops, back up here. Some lawyers will give you a quote. If you want justice, it's $200 an hour. Obstruction of justice runs you just a bit more. But the real question for the poor person accused of a crime, of course, is that they can't afford any justice at all. And so the question is, how much justice is the society going to give them? And as long as I have been in this work, the answer has been that we have been told that the state and local governments can't afford to provide a very decent level of justice for poor people accused of crimes. And I want to, just as Phyllis Mann did this morning, I want to put aside the federal government. Because first of all, the federal government deals with a fairly small number in the great scheme of things of crimes. Most of the crime is prosecuted in the state courts. And the federal public defenders are well funded, and most of them are independent. And we see pretty decent representation, at least in the places where I am, like Atlanta, our federal public defender office. They have very reasonable caseloads, they have very good resources, and the lawyers who are appointed are paid very well by the hour. So I want to put that to one side. What I'm going to be talking about for the rest of the time is in the state courts, which is where the great overwhelming majority of people accused of crimes are, and virtually all of them are poor. Almost, you go down and watch court, and virtually everybody is poor. You don't see Martha Stewart down there. You don't see the Enron people there. There may, every now and then, there's some kid busted with drugs or something like that, but the vast majority are poor people, people of color, who are being processed through this system. And of course they can't afford it. The states can't afford it. We know that the state of Missouri, the state of Texas, the state of Georgia, whatever state you want to know, they have the resources. The question is, how do they decide to spend those resources? And the question is, really, how much justice is going to be provided by the same government that is committed to convicting these people and denying them their liberty, and in some cases, even their lives? I mean, that seems to me to be the great riddle here. Why would the government frustrate its own purpose by providing legal representation to the people it's trying to convict, to imprison, and even to execute? Well, I'll come back to that. Let's take one look at the happy story in all this, because it goes downhill from there, and this is primarily for the law students. Gideon versus Wainwright. Some of you know this story and some of you don't, but this young man, this man over here, arrested for breaking into a pool hall in Panama City, Florida. And he demanded a lawyer at his trial, and he didn't get one. And he was sent off to prison in Florida, and he wrote his own petition. And you can't see a whole lot of it, but this is the paper that they gave you in prison that has the correspondence regulations and tells you how you're to do your correspondence. And he writes to the Supreme Court of the United States his very own petition. There's the stamp from the Supreme Court. And actually, if you read it, it's pretty good. Better than, unfortunately, a lot of work that lawyers do these days. It's only 5 pages. And he says back here at one point, whoops, let me back up a couple of notches. Whoops, going the wrong way. Sorry. You can see how often I do this. Counsel must be assigned to the accused if he is unable to employ counsel, and is incapable adequately of making his own defense. And he winds up by a wherefore clause there asking that the court provide him with lawyers. This is written in pencil, sent up to the Supreme Court. And some of you know this story if you've read Anthony Lewis's book, Gideon's Trumpet. Case gets up to the court. Abe Fortas, then with Arnold Fortas and Porter, is appointed to represent him, argues his case in the Supreme Court. At this time, the only right to counsel is in capital cases, the Scottsboro case, Scottsboro, Powell versus Alabama. Of course, Justice Abe Fortas is later appointed to the Supreme Court and writes one of the more important right to counsel cases, Galt versus In re Galt, the right to counsel for children, later on. What's interesting is that 22 states, while the case is pending, 22 states come in support of Gideon's position that poor people accused of a crime have a right to a lawyer. Walter Mondale, later vice president at that time, the Attorney General of Minnesota, leads the effort to have states come in and say, if we're going to have a fair criminal justice system, then poor people accused of crimes have to be represented by counsel, for goodness sakes. Only 2 states, North Carolina and, of course, Alabama, support Florida's position that people are not entitled to a lawyer. And, of course, in the landmark case, unanimous decision by the Supreme Court holding the Sixth Amendment applicable to the states, the court says, yes, you're entitled to a lawyer. That every person facing a felony charge is entitled to a lawyer. And Gideon goes back to Panama City, and this is Anthony Lewis's article in the New York Times. He's retried, he has a lawyer, and he is acquitted. And the sentence there, which I brought up for you, the difference between the 2 trials was that this time, Mr. Gideon had a lawyer. Lawyers actually do make a difference. In the book Gideon's Trumpet, Anthony Lewis says, it will be a tremendous task to bring to life the challenge of Gideon versus Wainwright, the dream of a vast, diverse country in which every person accused of a crime will be capably defended no matter what his economic circumstance, and in which the lawyer representing him will do so proudly, without resentment of an unfair burden, and with the support necessary to provide an adequate defense. Of course, it's not a dream, as he said there. It's a constitutional requirement. It's not something that's a good idea to provide lawyers for people. It's constitutionally required. There's no constitutional requirement to pave a road to anywhere. But there is a constitutional requirement to provide lawyers, and of course later the court held, in any case in which someone could lose their freedom, there's a right to a lawyer. It's not optional. It's not a good idea. It's absolutely required. But of course this was a judicial opinion. This was an unfunded mandate from the federal government. There was no agency to go about administering the daunting task of implementing this decision. It was going to be enormously costly if done right. Of course, a lot of people did it wrong, particularly in a lot of the states that conscripted lawyers. For a long time, if you remember the bar, part of the deal was you represented people accused of crimes. You might be a tax lawyer, you might be a real estate lawyer, whatever. When your turn came, you got whatever the case was, you handled it as little as you could, and moved on. And that's still the practice. Not long ago, a lawyer in Gainesville, Georgia, filed a lawsuit saying, I'm a real estate lawyer, I practice out of my home, I do title searches and real estate closings. And yet I get appointed to these cases involving these kids who are facing incredible amounts of time. I don't have the personality. I don't like to go into court. That's why I don't go into court. That's why I do real estate closings and title searches. And yet I'm assigned these cases, and I'm told that as a condition of practicing law, I have to take these cases. He hired his own lawyer and filed a lawsuit asking to be relieved of conscription, of being appointed this way. In the Southern District of Georgia, to this day, the federal Southern District of Georgia, every single lawyer who is a member of the court has to take criminal cases. Absolutely ridiculous. But that's pretty outdated. Robert Kennedy was the Attorney General of the United States at that time, and he said the poor person accused of a crime has no lobby. And that is the great problem. That as this decision came down from the Supreme Court, there was no lobby. There was no one to go to the legislatures and say, this is what we have to do. It's interesting that in Florida, Ferris Bryan, the governor, within days of coming down, said to the legislature, we've got to have a public defender system. We have got to respond to this opinion with a public defender system. And within 2 months of Gideon being decided, Florida's legislature, and maybe one of the last things they did in indigent defense, passed a law creating a public defender system in Florida in every judicial circuit, parallel to the state's attorney's office, a public defender system. And that system nurtured offices or developed offices in Miami and Tampa and St. Petersburg, Jacksonville, and other places that had some of the finest public defenders and some of the great public defender offices that we've had in this country because they've been there all that time. I don't know if you've ever seen the documentary, but I would recommend it, Murder on a Sunday Morning. It's about 2 veteran public defenders in Jacksonville, Florida, representing a young man, Brendan Butler, who's identified and accused of a murder. Let me tell you, they represent him. I'll tell you how it comes out. It comes out pretty well for Brendan Butler, even though he was said to have confessed, even though he was identified. If that crime had happened on the other side of the line, the state line, if that crime had happened in Georgia, that young man would be rotting away in some Georgia prison today. But because it happened on the south side of the line, in Duval County, Florida, he had real lawyers representing him who investigated his case and ultimately found the person who actually committed the crime and were able to prove his innocence. But today in Miami, the public defenders are so overloaded with cases that they've sought relief in 2 different cases where they have brought actions in the courts, and they have too many cases. They can't represent their clients. They can't meet their ethical obligations. They can't meet their legal obligations to their clients because they have so many cases. One of those cases, the trial judge, the head of the criminal division, a judge who's presided in Miami for 16 years, who's heard criminal cases throughout that time, had an extensive hearing, took testimony from Norm Lefstein and many other people, heard testimony of a tearful public defender, Amy Weber, one of my students at Yale many, many years ago, who told of not being able to take advantage of a plea offer for one of her clients because she's in trial in another case and she couldn't get the judge to release her from the trial to go take advantage of this plea offer. She's just so overloaded with cases, she just can't be everywhere at once. And at the end of the hearing, Judge Blake grants relief, and he says the public defender office can decline representation of third-degree felonies, a certain class of cases, until they can get their caseloads under control and until their lawyers can give each client the individual representation that the Sixth Amendment requires. And the lawyers can discharge their ethical duty of representing each client competently. The state takes an appeal to the intermediate, well, it bounces around, but it ultimately ends up at the 3rd District Appellate Intermediate Court. And the court not only reversed the case, not only reversed this protection that the trial court had provided, but one judge concurring says this is nothing more than a political question masquerading as a lawsuit. The Sixth Amendment right to counsel? Here we have an example of the courts passing the buck to the legislature on a constitutional question. Hugo Black said in Chambers versus Florida, the courts are havens of refuge for those who are outnumbered, who are despised, who are hated. It's the courts where you come for protection of your constitutional rights. You don't go to the legislature. You don't go to a bunch of demagogues up there in Tallahassee. They're not going to protect your rights. If you're poor, if you're accused of horrible crimes, that's not where you go, is it? No. You go to the courts because they have a responsibility that no matter how popular or unpopular you are, they're supposed to protect your rights. That's where you go. So while Florida had a public defender system in 1963, it's failed to maintain funding of it, and now the whole system is in crisis. The crisis we see everywhere around the country, caseloads. Too many cases, too much work, not able to do what should be done. But as was alluded to earlier, we see some cases that even today, some states, like Texas and Alabama, that don't even have systems. There's no system. You talk to people about it, they say, well, what's the system? Well, there is no system. In Texas, Alabama, the judges just appoint lawyers. They appoint whoever they want to. Judge McScadden in Texas, in Houston, he was talking about how wonderful the system is. He has 3 public defenders that he appoints. They work for him all the time. They're in his court all the time. His 3 public defenders. They contribute to his campaign when he runs for re-election. He has them there in his courtroom as his 3 public defenders. Now, who do you think they're loyal to? They loyal to their clients. I'll never forget meeting with this system was used in Indianapolis, not anymore, thanks again to Norm Lepstein. But I remember meeting with a lawyer about a capital case, and the lawyer was totally unprepared, and I said to him, you know, you have to get a continuance. He said, well, I can't move for a continuance. I said, well, you have to get a continuance. You're totally unprepared. You haven't done, I listed off all the things he hadn't done. He said, you don't understand. If I move for a continuance, I lose my job. The judge that I work for will remove me from my job if I move for continuance. So you have lawyers who are loyal to the judge, not to the client. Of course, as we all know, right? We all know this, that your loyalty is to your client. You have a duty of loyalty to your client, not a duty of loyalty to the judge, but if you're dependent upon that judge for your livelihood, if you're a lawyer who is at the absolute bottom of the profession, whose only work is the court-appointed case, $50 a case to meet and plead people, you've got to stay on the good side of that judge. And your loyalty to the client is going to be secondary to the loyalty to the judge. Other places like Georgia and Montana created systems just a few years ago, 2005, both those states. Georgia created a system, and at least we have structure now. At least there's a structure. At least in each judicial circuit there's a public defender office. If some young lawyer wants to go out and represent poor people accused of crimes, at least they don't have to just put up a shingle and hope the judge will appoint them. But then there are all sorts of other things that are absolutely essential resources, so the caseloads are reasonable. Independence. Is this office representing clients? Is it loyal to the clients? Or is it clerks for the judge? Who does the office, or for the governor, or for whoever else? Who does this office, always ask people, are we processing people through the system, or are we giving people individual representation? And too often, it's the first. Too often, it's the first. I go to courtrooms where it looks like a slave ship is docked outside the courthouse. All these black men brought in, handcuffed together, orange jumpsuits, very degrading. They're fill up the jury box in the first couple of rows. And then this lawyer comes in and he talks to each one of them. Of course, it's not confidential. They're handcuffed to each other. I mean, if I'm talking to you and you're handcuffed to him and you're talking to him, I mean, it's not confidential. In fact, I can hear. I'm sitting right there. I can hear the conversation. It's not a very long conversation. It's here's what the plea offer is. Here's what you get. All right. Right on down the road. Short time later, His Honor takes the bench. Everybody hobbles up to the podium. Their chains. Plead guilty. Get sentenced. On we go. That's it. Meet them, plead them, sentence them. That's all the justice they get. And that's not much representation. You got to have independence. You got to have training. We got to train people to how we represent clients, how we practice our craft, how we represent people in different kinds of cases, sex cases, murder cases, all the different kinds of forensic evidence and so forth that public defenders and criminal defense lawyers face today. We got to have competent management. You remember after FEMA, that we found out that, or after Katrina, we found out the guy that headed FEMA, Brownie, the famous Brownie. Remember that? Turned out he'd been the head of the Arabian Horse Association. You know, it's not very good qualifications to run a disaster relief agency. The head of our public defender system in Georgia is a mule trader. I kid you not. I mean, we're several notches down on the equine food chain. You know? And I mean, you know, everybody needs a job, but training mules has nothing to do with the Sixth Amendment right to counsel. Nothing. And so we have a system that's run by someone who knows nothing about the right to counsel, cares nothing about the clients. I remember we took his deposition the first time. We've sued him so many times now, I've forgotten how many times it's been, but I remember asking him at the deposition, I said, now when you first took this job, you didn't know anything about indigent defense, did you? No, I sure didn't. In fact, when he took the job, he came to the people at his office and he said, you know, I didn't want this job. But the governor called, the governor said, you got to take this job. I said, oh, no. What did that do for morale, you know? Now they don't say, we don't want you to take it either. But I asked him, I said, well, when you took the job and you know you didn't know anything about it, did you do anything to study up on it? Did you consult with anybody? Did you read anything? And I could tell by the look on his face, that was the first time he'd ever thought of this. Oh! No, I hadn't done any of those things. But now that he thought of it, he still wouldn't do it. So we have in Georgia the problem of inadequate funding. The legislature created it, but then the next year it came time to fund it. Well, about a fourth of what it took to run the system is how much they gave. And so we've had repeated instances of people accused of crimes that have no representation at all. I argued a case in November in the Georgia Supreme Court. You can go to our website, www.schr.org. You can actually see the oral argument, mine and the state's. Jamie Ryan Weiss, mentally ill guy, tried to commit suicide 3 times now. 3.5 years since he was arrested, and for a whole year there, he did not have any lawyer at all. He's facing the death penalty. He has no lawyer at all during that time. How can this be? How can a person be facing the death penalty without a lawyer? During almost all of that time, all but 6 months, no funding for the defense at all. No funding to pay his lawyers, no funding for experts, no funding for investigation, none. Prosecution has all the resources in the world. They've got their police officers, their crime lab, their prosecutors. They've got all the resources in the world. But the defense, no money. Well, we don't have any money for the defense. The great state of Georgia, with all the money it has, it doesn't have any money for the defense of a capital case. There's another case pending before the court where there's been no funding for the defense for 5 years in a capital case. Another case, Stacey Sims, got 2 lawyers appointed. They represented him for 1.5 years. At the end of that time, they said, we haven't been paid. They moved to withdraw. They moved to withdraw? What the hell? What kind of lawyers are moving to withdraw? Why don't you move to dismiss the case? But no, they moved to withdraw. Judge says, well, you haven't been paid, so granted. 2 more lawyers. 1.5 years. They hadn't been paid. Move to withdraw. What a defense bar. They are granted their motion to withdraw. So 3 years into the case, he virtually has had no representation whatsoever. Then we find out that up in the Northern Judicial Circuit, which is 5 counties up in northeast Georgia, up around Lake Hartwell, for those of you who know anything about Georgia, we find out that the head of the public defender, our mule trader, forgot to renew the contracts for the lawyers that do conflicts. That is, when there are 3 defendants accused, the public defender represents 1, but then there have to be lawyers to represent the other 2 defendants. Forgot to renew the contracts. I mean, I can understand you go to the grocery store and you forget to get the milk, but forgetting to renew the contracts for lawyers that represent people in felony cases, I mean, that's a little different. At any rate, the judges there didn't feel like they should appoint these lawyers if they weren't getting paid, and so they went. A lot of people have trouble believing this, but I promise you this is true. They went for an entire year without providing people with lawyers in felony cases. We found out about it by reading it in the Atlanta Constitution, so we figured probably the public defender knew about it. And it was in the Constitution in September. So I said, well, maybe we ought to go up there and see if this is really true, because, I mean, these judges, there are 3 judges in the circuit, they all took an oath, I think, when they got sworn in and when they got sworn into the bar to uphold the Constitution of Georgia and the United States. And the last time I read them, they both guarantee the right to counsel. There's a district attorney. He took an oath to uphold the constitutions of Georgia and the United States. There are people being processed in felony cases without lawyers are being called upon to enter pleas. There's a case called Maryland versus White, or White versus Maryland. It says you can't call upon a person in a felony case to enter a plea without that person being advised by counsel. Of course, I guess if you've decided not to comply with Gideon, you might as well just say to hell with the whole Constitution. Let's just play it by ear, let's just go back to the pre-Gideon days and a little trip down memory lane, You can sort of have the Georgia Historical Society come and watch. This is the way it used to be. Back before 1963, this is the way we ran the courts in Georgia. We still run them that way today. We fought a class action lawsuit about it. So what do? They get contracts. They hire lawyers on these contracts, 175 cases. Norm said today, in the earlier panel, this notion of 150 cases. The good lawyers will tell you 150 felony cases is unrealistic in a year. These lawyers, private practice, they have to maintain a private practice, and they contract to do 175 felony cases on the side, as we say, for $50,000. Now, what kind of justice are you going to get there? Well, the old adage, you get what you pay for, I think applies there as well. And there's just all these examples. 4 co-defendant murder cases, represented by one public defender office with different lawyers, but one public defender office with one investigator. I mean, come on. And they're all pointing the finger at each other. If you haven't learned this, that's called conflict of interest. You can't do that. You can't represent any of them once you've done that. I've had people who've had to wait years to get lawyers for their appeals or motions for new trials. We had a judge this week that said, no, you can't do that. You've got to appoint lawyers. The very next day, the legislature was saying, the Georgia Bar and special interest groups want special treatment for criminals in Georgia. No, we don't want special treatment. We just want them to have lawyers before they've served their whole sentence. That's normal treatment. That's not special treatment. That's normal treatment. You go to Texas, the capital of capital punishment, it's Harris County. Harris County's had more people executed than any state except Texas itself. Well over 100 people sentenced to death in Houston, Texas, have been executed in the modern history of the death penalty. People ask me a lot of times, why have so many people been executed in Texas? And I'll give you the quick answer. No due process. It's amazing how quickly you can execute people if you don't give them due process. You give them a terrible lawyer for their trial, terrible lawyer for post-conviction, those cases just go right through the system. 3 cases in Houston, just sort of one example, and I'm not saying every case is like this, but it just shows you 3 cases in Houston alone where the lawyer slept through the trial. One's been executed. One got relief after the Fifth Circuit struggled mightily with the case. First denied relief, then went en banc. I was at the en banc argument. There we had life tenure judges asking such questions as, how do we know the lawyer slept through any important part of the trial? Well, we don't really know because the lawyer who was in charge of making the record was asleep during the trial. He wasn't really making a very good record. He did say one time the defense rests, but I don't think that's what he meant. And then the other question, which I thought was indicative of sort of how low we've come, well, we've upheld cases where the lawyers were under the influence of alcohol, drugs, and we upheld one case where the lawyer was suffering from Alzheimer's, so why shouldn't we uphold this case? That really is a great comment on the legal profession. And the answer to that question, for those of you who are wondering why, seems logical, the answer to that question is, well, a lawyer who's impaired by drugs, alcohol, or Alzheimer's is at least conscious. Whereas a lawyer who's asleep is unconscious and therefore is absent from the trial. And so, when I thought sitting there, down there in New Orleans, this oral argument, 14 life tenure judges, Solicitor General of Texas, lawyer for Calvin Burdine, I thought, I'd hate it if a bunch of 8th graders came in here and watched this argument. I mean, what does this say about the legal profession? We got all these lawyers up here arguing about whether a man who had a 16-hour death penalty trial was denied a fair trial by the fact that his lawyer, his only lawyer, he only had one lawyer, and his lawyer slept during the trial. I mean, come on. I mean, what if you had a surgeon who slept during the surgery? What if you had a bus driver who slept during the trip? I mean, what other profession can you sleep and not get fired? That's what I want to know. And these judges are taking this seriously, and you can look it up. You students go on your computer, Burdine versus Johnson, 5th Circuit, and don't read the majority opinion. That's the easy part. Read Justice Risa Barksdale's bitter dissent for 5 members of the court. This is a new obligation we have put on judges. They have to monitor the defense lawyers to see if they're awake or not. Well, I'm not saying the lawyers are all sleeping, but I'm just saying, when you've got that kind of dissent, and Barksdale had written the panel opinion upholding Burdine's conviction and death sentence, it just shows you what a mockery we've made of the Sixth Amendment right to counsel. And there are other, you can go state to state. Some panel this afternoon will talk about the Missouri and the situation here. Long delays, excessive caseloads, no money for investigation or experts, articles and studies that Norm and other people have done, most recent being the National Right to Counsel Commission. But counsel is the most fundamental thing for a fair trial. The adversary system cannot work without people being adequately represented, and the consequences are enormous. The New Yorker just not too long ago, ran this case study of how an innocent man named Todd Willingham was executed in Texas, sentenced to death because the lawyers who represented him knew absolutely nothing about representing someone in an arson case. And another man, Ernest Ray Willis, also sentenced to death because he had lawyers that knew nothing about an arson case. But Willis was lucky. He had the good fortune to have a law firm from New York that represented him on post-conviction. And they spent the money to get the forensic experts and the consultants who were knowledgeable to analyze the evidence in the case and to point out that the testimony was total junk science. That when the jury was told things like, well, the reason this glass has all these crazy cracks and things on it is because an accelerant was used. And the people that really knew their stuff said, the reason the glass looked that way is because it was hot when the fire department sprayed water on it trying to put out the fire. That's what happens to glass when cold water hits hot glass. It doesn't mean that there was an accelerant used. And they explained everything. And Willis is free. He walks out a free man. Willingham is executed, and then the same people look at the evidence in his case and say, this wasn't arson. This guy didn't kill his babies and his wife, which he had no motive to do. But he's dead now, so there's nothing we can do about it, as we so often see. If you change the patterns, if you change the lawyers in those two cases, you change the outcomes. If that law firm had taken Willingham's case, he'd be alive today, and Willis would be dead. But that's how. NPR profiled this lawyer in Detroit, Bob Slomenko. 40 years of handling court-appointed cases, 40 years. Michigan just has a horrible system up there, every county still, over 80 counties. This lawyer was reprimanded by the bar 16 times. 16 times. He's representing poor people. That's all he's doing. Like other court-appointed lawyers, he doesn't go to the jail because he doesn't pay anything. Doesn't accept their phone calls, doesn't meet them. All he does is meet them in the lockup. And he had one client named Eddie Joe Lloyd. Never met Eddie Joe, never accepted his phone calls during 2 years of representing him. And when Lloyd complains to the bar, this is what the lawyer writes back. This is a sick individual who raped, kidnapped, and strangled a young woman. His claim of my wrongdoing is frivolous, just as is his existence, and both should be terminated. That's his lawyer. Short time later, Lloyd was freed after 17 years in prison when the DNA evidence showed that he was absolutely innocent of the crime. And he died just 2 years later. Some people think this DNA evidence is going to keep innocent people from being convicted, but that's only 10% of the cases. The other 90%, there is no biological evidence to be tested. And in those cases, we have to work on a properly working adversary system if we're going to bring out all the facts and enable courts to figure out what the truth is. Of course, there are a lot of other consequences, not nearly as dramatic. The client who stays in jail for 2 weeks after being arrested, who loses his job and therefore loses his home, who goes from being right on the margins of making it in society to being a homeless person. That too is a tremendous consequence which puts somebody's life in a downward spiral from where it was before. There's no such thing as a small case in the criminal justice system when we're talking about somebody's liberty. And of course, as was talked about earlier, we've got a standard of review of competence that makes them just as an embarrassment, I think, to our profession, the Strickland versus Washington. We didn't find out until 1984. Gideon's decided in 1963, not until 84 did we find out what it even means to have an effective lawyer. And the court said deficient performance and then substantial probability that affected the outcome. And as Justice Marshall pointed out in his dissent, this is such a malleable standard that it's totally in the eye of the beholder. And so we see courts, just this, and then in the federal courts, and on top of that, we have the Anti-Terrorism and Effective Death Penalty Act. So the courts are even more deferential, as if they're not deferential enough to the state courts. Just this term in the Supreme Court, Wood versus Allen, this is a case of a young man named Hollywood. Now, if your name is Hollywood, your parents are either extraordinarily cruel or extraordinarily stupid. In his case, it was the latter. This young man is mentally retarded, and mentally retarded seems to often run in families. Tested in the 60s, IQ-wise. He was in especially the classes for the educably mentally retarded. And in typical Alabama fashion, as I said, Troy, Alabama, they kept the mentally retarded kids down in the basement in what was called a mole hole at the school, and the kids who were down there were called the moles. And he was represented by typical Alabama lawyers walking violations of the Sixth Amendment. They never went to the school, they never talked to the teachers, they never put on any evidence of this. I can't imagine anything that could have been more compelling in mitigation. The Supreme Court, it was decided 2-1 at the 11th Circuit, Judge Rosemary Barquette dissenting, saying that the majority of the court, the 2 judges in the majority, had gotten lost in what she called a bramble bush of procedural bramble bush. It goes up to the Supreme Court, and the Supreme Court gets even more lost in the bramble bush. If you heard the oral argument, it was all about numbers and letters. It was nothing about Hollywood. It was nothing about his lawyers. It was all about habeas corpus. It was all about E1, D2, all these numbers and letters and back and forth. And 7-2, he loses. And it's a great miscarriage of justice, and it's just losing, it's what's happening increasingly, it's just losing all these things in this procedural morass that the courts and the Congress have created. And pretending that these lawyers were somehow something that they weren't, which was terrible, and that the trial that he had was somehow fair when it wasn't, it was a farce. But he'll be executed by the state of Alabama once the mandate comes back. One case that sums up what the courts are doing is a case out of Kentucky. Jeffrey Leonard, who was a 20-year-old brain-damaged African-American man who was tried and sentenced to death by a jury that literally didn't even know his name or anything else about him. He was tried under the name James Slaughter. And I will tell you, as one who's tried some of these cases, that if you wanted to pick a name for your client in a death penalty case, it wouldn't be James Slaughter. His lawyer conducted no investigation, never found out that his client was brain damaged. The lawyer actually testified that he had tried 6 death penalty cases. It was a lie. That he had headed an organized crime unit in New York. It was a lie. Sixth Circuit nevertheless upheld it. No problem. Said the outcome wouldn't have been any different. Guy Cole, judge on the court, wrote this in dissent. We are uneasy about executing anyone sentenced to die by a jury that knows nearly nothing about that person. But we've allowed it. We're uneasy about executing those who commit their crime at a very early age, but we've allowed it as well. We're particularly troubled about executing someone who suffers from brain damage. We rarely, if ever, allow that, especially if the jury has not been able to consider that evidence. Jeffrey Leonard, known only to the jury as James Slaughter, approaches the execution chamber with all of these characteristics. And reaching a new chapter in our death penalty history, the majority decision now allows all of that. It cannot be reconciled with established precedent, and it certainly fails the Constitution. Judge Alvin Rubin on the 11th Circuit said, and summing this up, the Constitution as interpreted by the courts does not require, look at this, that the accused, even in a capital case, be represented by able or effective counsel. Consequently, the accused person who are represented by not legally ineffective lawyers may be condemned to die when the same person, if represented by an effective lawyer, would at least receive the clemency of a life sentence. That's saying a lot, isn't it? That we have a standard of effectiveness that the Constitution says you're not entitled to be represented by able or effective counsel. In theory, the right to a lawyer is supposed to be enforced in post-conviction relief. But the catch-22 there is you're not entitled to a lawyer for post-conviction relief. So for the vast majority of people, that's a totally hollow right, because they're never going to have a lawyer to raise it, and there's a statute now that we have statute of limitations in virtually every state and statute of limitation in the federal government. So that's just a catch-22. As I said earlier, Texas provides lawyers for death penalty cases, at least, that are as bad or worse than the lawyers that they provide at trial. 9 people in Texas have been denied any post-conviction review at all because the lawyers that were assigned to them, not that they picked, that were assigned to them, missed the statute of limitations for filing. That is, they couldn't even get the papers in on time. 9 people, 6 last time I checked, had been executed without any post-conviction review at all. 3 more waiting to be executed. They're dead men walking. They have nowhere to go, no court to go to. They have missed the statute of limitations. And the most remarkable thing is that 3 of those people was represented by the same lawyer. And the question I have is, how can any bar association, how can any court, the Texas Court of Criminal Appeals, that claims to care anything about fairness, allow this to happen? How did he ever, after missing it the first time, was he allowed to have a second client and a third client? And right now that lawyer, Jerome Gottnich, is representing over 300 people in felony cases in Texas, including people in capital cases. We just don't care. We've seen other cases in Texas where people were represented by lawyers. One case where the lawyer copied verbatim the brief that he'd used 2 years earlier in another case. There was no changes in it. It had the same witnesses and so forth discussed. He even had the same grammatical errors in it. But it gets worse. Some lawyers had copied their clients' letters and filed them. 90% of the brief filed on behalf of Daniel Acker was written by Acker. Written by Acker. It was incoherent, it was repetitious, it was rambling, it had things in it like, I'm just about out of carbon paper, so before I run out, I want to try and list everything that was added and taken from me before my conviction on the next page. This is in the brief. a letter to the lawyer about he's running out of carbon paper. And there's example after example of all this. These lawyers have paid $25,000 a case. The courts have completely lost sight of justice in this tangle of procedural rules and pretenses and administrative concerns, to where we're now at a point where finality and not justice is the ultimate goal. Moving dockets, not competent representation, is the concern of our courts. Technicalities. Procedural rules that were made up by the courts and then by the Congress. And at bottom, a lack of courage on the part of the courts. But this system has its defenders. And I just went in, we're talking about one of them, Justice Richard Posner. Now, he and I agree on one thing. He says, I can confirm from my own experience as a judge that criminal defendants are generally poorly represented. Goes on to say, but if we are to be hard-headed about it, we must recognize this is not necessarily a bad thing. If the lawyers who represented indigent defendants were any better, or the lawyers at least seem to be good enough to reduce the probability of convicting innocent people to a fairly low level. If they were much better, either many guilty people would be acquitted, or society would have to devote, this is law and economics now. Okay? Law and economics people? Or society would have to devote greater resources to the prosecution of criminal cases. A bare bones system of indigent defense may be optimal. Now notice what he missed here on the last page. He said if the lawyers were any better, more guilty people might be acquitted. He missed the point that if the lawyers were any better, more innocent people would be acquitted. That didn't even occur. And of course, this bare bones system, it's only for indigent people. It's not for the, not for the commercial cases, not for rearranging the assets of the upper 1% or whatever else. It's only for poor people. It's not even for criminal cases of wealthy people, just for indigent people. Well, this is not about being tough on crime or soft on crime. It's about whether we have a fair and a reliable system for deciding guilt or innocence. And we've convinced ourselves, I think, in many parts of the country that we just can't afford it. And that's nonsense. I go all over the place. When I was in Georgia and we were fighting for indigent defenses in Louisiana and other places, and this is something I hear all the time. We don't want a Cadillac. We just want a Chevy. That seems to be a sort of standard in Georgia to say, these people aren't entitled to zealous representation. They're only entitled to adequate representation, whatever that is. And I'm sitting there in these meetings and I'm thinking, well, I don't understand this. I mean, why wouldn't we want a Cadillac? I mean, we're talking about life and liberty. I mean, yeah, this is a very materialistic society. But why wouldn't we want a Cadillac if we're talking about life and liberty? I mean, holy mackerel, this is the United States of America. We can spend billions of dollars to fight wars in Iraq and Afghanistan. Why can't we just spend a fraction of that to have a decent criminal justice system that fairly processes people? This is a poverty of vision with regard to what kind of justice we're going to have, and it's an indifferent to injustice. And I want to just say, the reasons: one, unwillingness of legislatures to fund; second, unwillingness of courts, state courts that are elected, that depend upon the legislatures for their budgets to enforce the right to counsel; indifference on the part of the bar, I'm afraid, to what happens to the poor people in the legal system; ignorance on the part of the public, because the criminal justice system is out of sight and out of mind. It's a system for the poor, and it's largely for racial minorities. But increasingly, I have very sadly and reluctantly come to the conclusion that there is a strategic element for prosecutors in keeping the quality of representation for poor people as bad as it is. And I'm very sorry to say that. Because I like to see the best in everybody, and I try to believe that everybody is, like I learned in civics when I was in school, try to believe that our courts are not totally corrupt, just simply indifferent, that our judges and our prosecutors are acting in good faith, that they've just been acculturated to a system that they don't think they can change. But I have seen too much. I have seen district attorneys move to remove competent lawyers from cases and replace them with public defenders who have so many cases they couldn't possibly represent the client. And the judge granted the motion. I've seen those 3 judges and that district attorney that I told you about process over 300 people without lawyers, not blink an eye about it. I've seen judges and prosecutors sit through the meet 'em and plead 'em sessions in courthouses all over the South, knowing good and well that this is not any kind of system of justice. I've seen prosecutors and judges oppose funding for indigent defense and for public defenders. And it's not just fighting over the same money. It's actually fighting to keep these programs as bad and as poor and as overworked as they are. And I've seen too many prosecutors and judges say that this lawyer is capable of handling a death penalty case when I know good and well they wouldn't have that lawyer represent a member of their family in traffic court. We all know it. And it's just a lie that's being perpetuated to try to justify a system that we know good and well. Know good and well. We would never go to that lawyer. And I think we can't be, the public can be ignorant, but the legal profession cannot be. And we're going to come to a reckoning, and it's going to be while you law students are in the bar. We're going to come to a reckoning, and if we can't do any better than this, we're going to have to sandblast the words equal justice under law off the front of the Supreme Court. Because at one time, at least we could say it was an aspiration. What Justice Black said. There can be no equal justice when the kind of justice depends upon the amount of money you have. But at least we're trying to get there. If we're not, if we're in full retreat, if we're not even trying, if we are saying that a bare bones system of indigent defense may be optimal, that we're going along with the program, then we can't say equal justice under law. Maybe we can say your American Express card, welcome here. Maybe we can put that on top of the courthouse. Because we're trying to nickel and dime these people to death anyway, but that's another story for another time. We need to document this, and I think we need professors and students going into courtrooms. I tell my students the first day, go to the courthouse. Look at what's happening. Be shocked at the way people are being treated. At the way people are being, at the demeaning way in which people are being treated, at the little time many people get. The National Capital Jury Project has done a marvelous job of educating us on how juries think and act. And we need a similar kind of effort to go into courtrooms, not to write about the cases and the decisions and how bad the Strickland opinion is. We all know that. But to actually go into courtrooms and go to Calico, which is arraignments, and look at what's happening there in the courtrooms. And to the law students, I am calling upon you. Every law student here, I don't care what you do. I don't care if you're a prosecutor. I don't care if you're a law firm lawyer. I don't care what you do. You've got a responsibility as a member of the legal profession. You are a trustee of justice because you've got a monopoly. And that monopoly is not just a get-quick-rich scheme. It is a get-quick-rich scheme. Don't get me wrong. And you can get rich quick as a lawyer. But you've got a larger responsibility to the integrity of this justice system. And it means that the justice system, as it operates in the criminal courts, has to have some integrity. And the lawyers have to take responsibility for it because nobody else is going to. And that's one thing that no matter what you do, you can talk about why we have to have an effective indigent defense system, and you can make it happen as lawyers, particularly if you're prosecutors and bar presidents and muckety-mucks in the bar. And the other thing you can do, and this is a great thing about being a lawyer, is you can work on an individual level if you decide to do that as public defenders, helping one client at a time. This is like the Underground Railroad. You may not be able to change the whole system, but we can help people one at a time get through this time. And the legislatures may fail, courts may fail, executive branch may fail, but individual lawyers can take cases, can counsel clients, can tell their stories in court, and tell their stories to the world until we do something about this. And it will make a difference. It will make the right to counsel a reality for that person, for that person's family, for their children, for their spouse, for whoever it may be. Realizing equal justice and the right to counsel is going to take a sustained effort over a long period of time. It's not going to be solved, maybe even in your career at the bar. But as Dr. King used to say, we stand on the shoulders of others so that other people stand on our shoulders. And in representing people and in working to improve the representation that poor people get, we stand on the shoulders of people like Thurgood Marshall, who not long after being admitted to the Maryland bar, after they wouldn't let him in the law school in Maryland, and he went to Howard, gets on a train and goes all the way to Oklahoma City, and then gets on a bus and goes to Hugo, Oklahoma, and represents a man in a death penalty case in Hugo, Oklahoma. Can you imagine? Early in his career. And Clarence Darrow, late in his career, trying a case to an all-white jury on behalf of African Americans who had had the audacity to move into the all-white neighborhood in Detroit on trial for murder, and faces that jury and says, this is a case about race, and talks to them about what's going on in that case and in that community and in this country, and wins an acquittal for the Swedes. There are those shoulders that you stand upon as we go forward. And I think we can say, no matter what's happened before, this time we can look at that challenge posed by Anthony Lewis and say, this generation of lawyers, which has seen what the mindless pursuit of wealth has done for hedge fund managers, for investment bankers, law firm partners, can say, we are going to respond to what Elie Wiesel said in his Nobel Prize speech, our lives are not our own, they belong to those who need us desperately. And Dr. King, who called upon us to be drum majors for justice, and to say this time, in the midst of this indifference and hostility and all this fear-mongering that's going on in our country, we're ready to walk into the bright sunshine of hope, promise, and confidence and say, we can make good on what the Constitution requires. We must make good on what the Constitution requires. And in our careers at the bar, we will settle for nothing less. Thank you very much.